Good morning. Now, another landmark judgment delivered by Supreme Court, which may give room for multi-number of cases being flown to courts at High Court levels also. Very important issue was decided by the Supreme Court. Actually, what had happened? The respondent. It's a case of AR 2023, Supreme Court 1956. AR 2023, Supreme Court 1956. Director Administration and HR, KPTCL, Karnataka Electricity Board, and others versus CP Mundinamani. Here, what happened? The employee was successfully completed his tenure of service till his age of superannuation, but the department did not grant him entitlement of his increment. But they say because you are going to retire, you are not eligible. Therefore, he approached the Honorable High Court single judge dismissed him. But before the division bench held stating that since his increment is based upon the service rendered by him with good conduct and without any adverse remarks, he is entitled for that increment. That was the division bench. Then the department went to Supreme Court. Supreme Court has decided this issue 11/4/2023 by interpreting the word occur. Occur means is a future payable future. They simply say that the increment is an incentive for future service. That was a somewhat mischievous interpretation argument by the department. Want to deprive the poor man's. Those arguments be done only by a few peoples, not by all. There you can differentiate from the advocate to advocate, judges to judges, how they deal with these issues. See, the Supreme Court says, no, it is not correct. Because his past service performance, he was being awarded increment. Therefore, they hold good the division bench of judgment and he was permitted to get the increment of last year service. What happens, see, it is not that 1 year increment, then if the increment is allowed, his pay scale will be refixed, because the pension is being calculated on the basis of last pay drawn. So automatically his last pay drawn at on the date of retirement will be a little bit high. Same with the gratuity and other benefits are being paid. Pensionary benefits are also being enhanced, and if there was some DADA increment additionals from the date of order, date of retirement and the date of in between the date of judgment, holding good about the increment entitlement, automatically he will get so many lot of benefits. So by following this judgment, multi-number of writ petitions may be filed if anybody was deprived of their right to increment at the verge of their retirement. That area should be deeply discussed by almost all advocates, and particularly I request our law quiz group members to deeply discuss whether any such judgment is prevailing in your states, particularly Karnataka or Kerala, so that we can and analyze the entire judgment, and the judgment is old good. That apart, we can also, my friends may also discuss about this judgment's applicability in central government services and other services pertaining to central government companies, paramilitary forces, and other things. So that the what was the concept decided when this court was, the increment is not for his future incitement. Increment is for the services rendered by him with good records. That was the concept. If that concept is accepted, it is very well you can file multi number of cases. It comes. Best wishes.